Welcome to today's webinars on GDPR for your daily activities. Consider GDPR in what you do and how to deal about it. This session is part of a wider cyber and privacy awareness training set up with the European Pro Bono Alliance. Presenting today is Diletta Cicco, an associate in the Brussels office, part of the cyber and data privacy practice, and me, so Charles Helleputte, a partner in the Brussels office of Meyer Brown, also part of the cyber and privacy practice at the firm. Today we will focus on some of your main daily activities and what it means as far as GDPR compliance is concerned, focusing on 4 aspects, so the subscription to newsletters, the organization of events, the fundraising campaigns, and stakeholder mappings if you happen to do that. Before we jump on those very important aspects of your day-to-day activities, we will also remind you of some GDPR key concepts, such as what is personal data, what is processing, what is a controller and a processor, a reminder on the legal basis for processing, some reminding as well on notice requirement for controllers, as well as the rights of data subjects. So let's remind us of 4 key GDPR concepts, starting with, of course, what is personal data. As you all know, personal data is any information relating to an identified or identifiable natural person. We all know that that means or receive a broad interpretation, and that, for example, things even like IP addresses can be considered as personal data falling within the scope of the regulation. Another important concept is the one of processing of personal data, and processing means any operation or set of operations performed on personal data or on a set of personal data. It covers, for example, not only online activities but also offline activities, and as an example, structuring a contact list in an organized way is a processing activity. 2 other important concepts to keep in mind is the one of data controller, meaning the natural or legal person that determines the purpose and the means of processing of personal data, and the one of data processors, so a natural or legal person that processes personal data on behalf of the controller. As we will see later on in the presentation, in a lot of the activities you will be doing, you will probably be considered as the data controller, but you might be relying on other parties to help you in some aspect of those activities, and those might be considered as data processor. People often say that GDPR is a principle-based regulation, and indeed, it is so for a number of reasons. Amongst others, because the regulation defines you or provides you with high-level guidelines on things that needs to be done when you deal with personal data and that people need to obey and comply with. If you narrow all of those requirements into core data protection principles, you basically can be down to 8 key principles, and they are listed on the slide. To start with, the regulation has or requires you to obey a principle of transparency, and that is providing data subject with the right level of information on what you are doing with their personal data. You need to tell people what you do with the data, but also you need to comply with the fairness principle, meaning that you really should be doing with data what you really told people you are going to be doing, and really treat them in a fair way. For lawyers, but for many others, you also need to comply with the lawfulness principle. We will come to that in a second more broadly, but one of the application of that principle is on the legal basis for processing, so you can only process personal data as long as you can rely on one of those set legal basis for processing. It's not because you want data that you can have them and process them the way you want. Another important principle is the one of a purpose limitation, meaning that by the time you are telling people that you are collecting the data for a certain reason, you really need to just do that and not use the data that you have collected for other purpose unless you have valid reasons to do so. We can then group the following two principles on security and integrity of data, because indeed, data controller and processor need to make sure that the data that they are processing are secured and are not compromised. The regulation imposes a number of requirements in that respect. You also need to make sure that the data you collect has a high quality, meaning, for example, that they are still accurate. And you need to have process in place to check and ensure that indeed the data you have has that high level of quality. Even more important probably for today's discussion is the principle of data minimization, meaning that you only have to collect and process those data that is really necessary for the use that you are contemplating. And now I'll hand over to Diletta to discuss the legal basis for processing.
As Charles mentioned, under the lawfulness principle, you will need a legal basis for processing every time you are planning to use personal data. The available grounds, so the available basis under the GDPR you may rely on to process personal data are listed in Article 6 of the regulation. So every time you are planning to process data, you are required to identify the legal basis you will be used, and you should assess which one will be the most appropriate for the type of processing you will carry out. The legal bases are mainly listed in the GDPR 6. We will focus later on three of them, which are the most likely to be used during your daily activities. For instance, you can rely on consent, so you can process personal data every time a data subject has given his or her consent to your processing of personal data. And we will see that in activities such as newsletter, this legal basis will be likely to be the one you will rely on. In some cases, you can also process personal data when the processing is necessary to perform the obligation you have under a contract you signed with a data subject, and we will also look into this legal basis in more details. You can also process personal data based on a legitimate interest you or a third party may have. There are then three other legal bases under Article 6 of the GDPR that will likely be used less during your processing activities, and those are the fact that the processing is necessary in order to protect the vital interest of an individual. The processing is necessary for the performance of a task carried out in the public interest, or for instance, the fact that you will need to process personal data because you want to and you need to comply with a legal obligation. So for instance, you may rely on these legal basis every time you need to process personal data to comply with tax law, employment law, and so on. One of the most famous legal bases under the General Data Protection Regulation is definitely consent. However, consent may not always be the most appropriate ground for processing your personal data. This is due to the fact that the GDPR introduced a high threshold for valid consent, and we will see what it means. And that's why every time you are planning to rely on consent, you will need to keep in mind all the new requirements for consent to be valid and implement them. The threshold for valid consent today means that consent must be freely given, and mainly this means that consent will be valid when data subjects don't fear negative consequences if they don't provide their permission to the processing of personal data, or for instance, consent won't be valid if there is an imbalance of power between you and the individual who is required to give his or her consent. And this is the main reason why consent is not the appropriate legal basis in most of the circumstances in the employment context. Consent should also be specific, and this means that you will need consent every time you plan to use data for a specific purpose, and if you want to use data in a different way, you are likely to need to require consent again from the data subject. So generally speaking, each purpose needs specific consent from individuals. Consent also needs to be informed and unambiguous. As we will see later on, under the transparency principle, organizations are required to provide certain information to individuals to get their information, and those information should cover specific aspects that are listed under the General Data Protection Regulation. Unambiguous consent means that every time a data subject provides his consent or her consent, should be able to clearly distinguish the information about consent, the information about privacy from all other terms and conditions, for instance. So consent shouldn't be bundled with other type of information that may mislead the individual. Today, consent should also be based on a clear affirmative action. This means that implicit consent won't be enough anymore. And this is why every time you go to a website or you subscribe to a newsletter, you are more and more asked to tick the box to actually provide consent. You should also be able to record consent. So you should be able to demonstrate that the data subject provided consent. And you should also provide individuals with the possibility to withdraw consent. Withdrawing consent should be easy and should be likely be possible in the same way as the data subject provided consent. So usually ticking the box, if an individual ticks the box to provide consent, he should also be able to opt out and untick the box to withdraw his or her consent. As I previously mentioned, you are able to process personal data under the General Data Protection Regulation, also when you need the data to be able to comply with your obligation under a contract you signed with an individual. This type of legal basis also cover pre-contractual steps. This is why, for instance, necessary for the performance of a contract may be used when an individual asks for a quote. You are likely to rely on this legal basis, for instance, in the employment context, when you plan to process your employees' personal data, for example, to pay salaries at the end of the month. However, you need to keep in mind that when you rely on this legal basis, a necessity test must be carried out. Conducting the necessity test mainly means asking yourself whether you actually need that personal data, whether you actually need that processing information to achieve your purpose and achieve your objective under the contract, and also whether you can process less personal data, or you can process personal data in a less intrusive way under the contract. And every time the answer to this question will be yes, so every time you can achieve the same objective by processing less data or processing data in a less intrusive way, this means that this legal basis, so necessary for the performance of a contract, is not the legal basis you should rely on. Legitimate interest is the most flexible legal basis under the General Data Protection Regulation, but this doesn't mean that it is also the most appropriate. When you plan to rely on your legitimate interest or on a legitimate interest of a third party, you mainly need to carry out a three-step test. First of all, you need to ask yourself what is your legitimate interest. So why you need the data, why you are processing them, so mainly what is your objective. As a second step, you should also ask yourself whether the processing is necessary, and this kind of test is very similar to the test we talked about when we discussed in the previous slide the necessary for the performance of a contract legal basis. If you pass these two, the first two steps of the test, you should then wonder whether there is a balance between your legitimate interest and the rights and freedoms of the data subject. The GDPR says that every time the legitimate interest is overridden by the rights and freedom of data subjects, you cannot rely on legitimate interest. What does it mean in practice? In practice, it means that usually when an individual could reasonably expect that you may use this personal data, his personal data or her personal data for the purpose, and that this processing of data will have a minimal privacy impact on the individual, you are likely to be able to rely on legitimate interest. Every time you conduct this test, you need to keep track of your assessment. That should, of course, be conducted on a case-by-case basis. So every time you plan to rely on legitimate interest and you think you have a legitimate interest to process personal data, you need to document these assessments in what is called the legitimate interest assessment. And this is actually a document you need to keep for your accountability under the General Data Protection Regulation. You should also keep in mind when you rely on legitimate interest that your privacy notices should include details of what is the legitimate interest and should provide information to data subjects about the interest and whether you conducted the balance test, and also what type of measure you put in place to minimize the impact on the data subjects. These slides give you an example of the steps you should consider when relying on legitimate interest. So as you can see, first of all, you should identify the interest and whether this is legitimate. You should then ask yourself whether the processing is necessary. So the main question here is going to be, do I have other way of processing data, and do I have other way of achieving my interest, maybe without processing personal data or by processing less data? As a third question, you should wonder whether the rights of individuals are put at risk by your processing of personal data, and whether you can actually increase the balance between your legitimate interest and the individual's rights. So, for instance, in the balance test, you can consider what is your relationship with the data subject, whether the individuals are likely to object to your processing of the personal data, whether there are measures you can put in place to minimize the risk of the data subjects. And then, as a last step, as I mentioned, you should be able to demonstrate compliance under the transparency principle, and you should keep track of your assessments, and you should then let individuals know on which basis you are processing their personal data. As Charles mentioned, under the transparency principle, you are required to be transparent in the way you process personal data, on what type of data you collect, on how you are planning to use the personal data you collect from individuals. The GDPR requires organizations that play the role of controllers, so the organization that actually has decision-making power about the personal data, to be comprehensive about the information they provide to individuals, but also to be clear about what they are doing with the personal data. This is usually done in what we call privacy notice. You may see privacy notice on the website. You may see privacy notice when you subscribe to newsletters, and they should be typically provided when data are obtained. That is why when individuals are, for example, required to sign up to newsletter, they should be able to see all this type of information, and they should be provided with a link to the privacy notice that will provide all these details. As you can see on these slides, here there is an example of the information provided on the Meyer-Brown website, where short and clear, high-level information are provided, and then a link is provided to the full privacy notice.
That the GDPR introduced is that it really empowered data subjects with a significant amount of rights that data controller needs to respect and fulfill. It's very important for you to have them on the back of your mind, because you will be confronted with the exercise of those rights, especially in a number of the things you are doing. Diletta mentioned already the fact that, for example, you will rely on consent to have people subscribing and receiving your newsletter, and we'll come to that in a second. But by the time someone wants to withdraw his consent and doesn't want to receive those newsletters anymore, data subjects have such right, and you will need to have procedures in place to respect those. If we quickly go through the various rights that the GDPR provides or empowers a data subject with, of course, as we had in the previous privacy legislation, people still have the right to rectify, so right to come up to you and say, for example, that the address that you have on records is not the good one, or that they change status or whatever. So that is the right that people have. They had it already, and they still have it today. The regulation add a number of other rights that, of course, have some links and ties with some of the legal bases that Diletta discussed earlier on. For example, under certain circumstances, data subjects have the right to object to some processing activities. That is, for instance, the case when you will be relying on legitimate interest. It is possible for a data subject to object to your use of that specific legal basis, and you will then have to engage with the data subject and be able to justify why your use of the legitimate interest as a legal basis is sound and valid. Otherwise, you might have to stop using or processing those data for these specific instances you were contemplating. Other type of rights that data subjects have, the right to restrict processing in certain circumstances, the right of access, so people inquiring you and check on you to see what kind of data you have on them, the right to be forgotten, so the right of erasure, so to speak, that you will also need to comply with unless you can rely on certain exemptions. And probably less relevant for you, but still important to keep in mind to have the full scope of the data subject rights is the right to data portability. So you having to comply with handing over a number of personal data that a data subject have provided you with to another data controller. So one of the questions you may ask yourself is why all of those rights are important. So for your end, those rights are important because you will need to respond to requests of data subjects exercising their rights, and you have strict timelines to follow to comply with those requests. Typically, by the time you receive a request from a data subject, you need to respond to that request within 1 month, even if extensions are possible. But that's not the only requirement you have. So in order to be able to identify that you are confronted with that kind of request and to respond on time, you will need to have a plan to ensure that you are ready to respect that deadline. You will also need to be able to locate and trace the personal data that you collect concerning specific individuals. For example, if what the individual is asking you is for an erasure or deletion of the personal data that you have on him or her, if you don't know where those data is located or are located, you will have hard time to obey and fulfill that requirement. If a data subject withdraw his or her consent or seek the deletion of the personal data, you should ensure that these rights are respected. And by the time, for example, someone is opting out of the newsletter, if you don't have a procedure in place that allows you to track that and know that you cannot send a newsletter anymore, of course, if the data subject opting out still receives the newsletter he arguably opted out for, you might be confronted with an angry data subject. So with that in mind, let's start and now review those specific activities that you are probably conducting on a day-to-day basis and check what it means for GDPR requirements. And we'll start with the newsletter one, and I hand that over to Diletta.
As I briefly mentioned before, the typical basis for processing when you plan to send your newsletter and your communication to individuals to inform them about your activities, your projects, your initiatives, is likely to be consent. But as I said, consent as a legal basis requires you to take some steps to make sure you are GDPR compliant when relying on these legal basis. Mainly, you are required to provide certain information when asking individuals to provide consent. They will need to know who you are, so the name of your organization, why you want the data, what you will do with the data. So the purposes of the processing, what type of communication you will send. For instance, also you may ask individuals how they want to receive your messages. If they want to receive your information, let's say about fundraising campaigns by post, whether they want to receive it by email, whether you may also call them to inform them about your activities. And also, every time they consent, you will also need to inform them about the fact that they are able to withdraw consent. So how they can actually opt out from your communication. Those are the aspects you will need to take into consideration for your valid consent. And sometimes you will also need to consider other sets of regulation, such as the e-privacy directive, and the future e-privacy regulation, which is in the course of being adopted and that actually address direct marketing. And direct marketing has been interpreted by European authorities in a broad way, and also includes communication such as newsletters, and may require you in certain countries to actually consider the different methods of opt-in, opt-out for individuals. On this slide, you can see an example of a e-newsletter sign-up form. We took it from the website of the ICO. The ICO is the Data Protection Authority for the United Kingdom, and this is the form the ICO requires individuals to fill in when signing to its newsletter. It gives us an idea of what type of language and what type of form and layout should be used for this type of consent form. As you can see, individuals are required to provide first name, last name, and email address. You can notice already that only necessary personal data are required, so everything you need to actually send a newsletter, like the email address or the name of the person, to be able to know who you are actually communicating with. The ICO then inform individuals about the fact that to be able to send the communication, it relies on a third party. In this case, this third party is called Adestre, and it's used to send the monthly newsletter. And also the ICO tell individuals something more. It communicates that technologies are used for statistics and analytics purposes on whether individuals open the newsletter or not. You can see then that, as we mentioned before, individuals are also provided with a link to a privacy notice, where, and we will see later on how it looks like, so where individuals can click whether they want to know more about the processing of personal data. Finally, at the bottom of the page, there is a submit button, a clear one, and that actually shows a clear affirmative action and provide a clear affirmative action for the individual who actually wants to submit to the ICO newsletter. So this is the web page you are directed to when you click on the ICO privacy notice link that we saw in the previous form to subscribe to e-newsletter from the ICO. As you can see, there is a list of all the types of information that are provided in the privacy notice. Those are the information that the GDPR requires controllers to provide to individuals. So you will find details about why the ICO needs the personal data, how they are going to be used. You will find also details about the data retention schedules. So for how long personal data about people will be kept, and what type of rights do people have, and how they can exercise them. The privacy notice from the ICO also gives us an example of what is called the layered approach. So on this privacy notice, individuals are able to click on a specific topic. For instance, if they are interested in knowing what rights they have, they are able to click on that specific section and get information on that specific domain. And this is actually more and more used by organizations to try to be comprehensive and clear about their privacy notice, but also to be user-friendly. So to try to provide information in the easiest way to individuals. An important step of compliance with the GDPR requirements when you rely on consent, and for instance, when you ask individuals consent to subscribe to your newsletters, is providing individuals with the real way to withdraw their consent. As mentioned before, withdrawing consent should be as easy as possible and should be as easy as providing consent. So, for example, ticking, unticking methods could be used. How it is done usually when you send newsletters to people you communicate with. Organizations usually include an unsubscribe option in all the newsletter sent out. So you will see more and more that when you receive communication from organization, when you receive newsletters, at the bottom of the email you will find a short sentence as the one you see displayed on these slides, where you are actually able to unsubscribe to the newsletter, and you will be then redirected to a website where your unsubscription is confirmed. Apart from including specific language in the bottom of your newsletter, you should actually also try to implement specific procedure to make sure that user choices are respected. So just providing language and providing a link for unsubscription won't be enough. If then your marketing team will keep sending newsletters to people who actually withdrew their consent. You will need to have clear policies in place, but also you will need to communicate them. So in this specific topic, awareness and trainings for your staff, especially the one that is likely to send newsletters and communication to people, is essential. And you will also need to make sure that unsubscription is dealt in the same way in all your team. And if you need, for example, to escalate unsubscription requests, this is done by all the teams in the proper way. Here we provide you with an example of the type of language you may include in your email footer when sending out newsletters. As you can see, the language actually summarizes all the aspects we discussed in the previous slides. So in the first sentence, you will actually find the list of the personal data that were asked from individuals to receive the newsletter. There is also a sentence that provides the link to the privacy notice to the individuals, and also that informs the individuals on the way they can contact the organization. And here you should actually you insert the email that is going to be the contact details for individuals for this type of communication, so for privacy related issues. And then, as we discussed in the previous slide, you will find the last piece of information on the methodology that can be used to unsubscribe. So you can include, for instance, an opt-out link, or you can ask individuals to send you an email and request unsubscription if this is the method you want to rely on. We will now focus on another type of activities that are certainly part of your daily work, and those are events. So when you plan to organize events for your organization, for instance, to promote your activities or organization of events about your project, you will need some personal data from the people who will attend your events. As we discussed before, one of the first questions you should ask yourself when you plan to conduct an activity that will need processing of personal data is on which legal basis you will rely on. And of course, these slides provide you an example of what could constitute a legal basis for the organization of events. But these assessments need to be conducted on a case-by-case basis, because it may, of course, vary depending on the circumstances. So the first thing you do when you organize events is, of course, running the registration process. In this case, you will ask people, you will probably send out communication, or you will publish on websites the announce of your events, and you will likely need the name of the person, contact information of the person, and email of who is planning to attend. In many cases, the legal basis for this kind of processing activity is going to be consent. So people will need to provide you with their personal data and consent to the processing of personal data that is needed to actually run the registration process. You will also need to, you will need to send over event information to attendees of your events. Sometimes, for instance, you may need to share information about the speakers, or let's say that your events will change location. You will need to update people about where they need to go to attend your events. And you may try in these cases to rely on legitimate interest. As we said, you will need to conduct a proper assessment, but of course you may resonate around the fact that you have an interest in letting people know information they need to know to attend your event. When you plan to send other types of communication to attendees, for instance, other emails about other events or other initiatives, or whether you plan to send emails about your newsletters to attendees of your events, in that case, you may likely need to require consent again, because it's going to be harder to demonstrate the link between these processing activities and the fact that an individual decided to join one of your events. They may not be interested in other type of communication from you, and you will need to ask their consent again. When you plan your events, unfortunately, legal basis is not the only aspect of the GDPR you need to consider. When you run the registration process, sometimes you may rely on third parties, and in this case, you will need to take steps to ensure that also processing of personal data by third parties is compliant with the GDPR. You will need to provide information to the attendees of your events. You will need to ensure that the sharing of personal data from your organization to, for example, the companies that run the registration process is GDPR compliant. And to add more complexity to this, there are also other type of legal requirements that may need to be considered in this scenario, like the one asking you to comply with publicity rights. When you ask personal data from individuals to join your events, so for example, name, email address, you will also need to provide certain information to those individuals. So we already discussed the fact that every time you ask personal data and collect information about individuals, you will need to provide them with the privacy notice. We also discussed about the fact that every time you rely on legitimate interest, you will need to provide details about this legitimate interest to the individual. And in this case, for instance, this will mean that if you are planning to send event updates to individuals, you should also tell them in the privacy notice that this type of communication will be carried out on a legitimate interest, and this is why you are not relying on consent. When planning events, also the GDPR inspired creativity from organization. You start seeing nowadays that organizations rely more and more on visual tools to get data subject consent. For instance, you may use bracelets, pins, or badges when you plan to take pictures during your events, and it's actually very hard to get real consent from each individual. So using different colors, different badges for people who consent to their picture to be taken or not, may be, for example, a creative way and practical way to comply with the GDPR. Or in some other cases, when you register to an event, you are required to send an email in the case you don't want pictures about you to be taken or to be posted. On the slides, you have an example of different type of consent you may ask individuals when planning to send communication. So in this case, for example, the individual is given the choice to consent to different type of communication, to consent to receiving different type of invitation to events, and is provided with the choice of saying yes or no, so a clear affirmative action to different data processing activities. And as always, and as we said, at the bottom of the page, a privacy notice link where individuals can get more information. As we did with consent for a newsletter, here we provide you with a practical example of what type of language you may use and you may include in your registration form to be compliant with the GDPR. As you can see, you have a first paragraph on describing what type of data are requested from individuals to register to the events. Then individuals are given the choice to opt in or opt out to different type of communication. Here, for example, you have future events or newsletters. Because as we said, it's going to be hard to rely on legitimate interest to send all these different type of communication to individuals. This is why you will need specific consent from them, and here this is done with an opt-in option. The language also inform individuals about the fact that the registration process is run by a third party. In this case, we took Eventbrite because many organizations rely on these service providers. And this, of course, means that when you rely on a third party, you will need to take all the necessary steps with that third party to ensure that the sharing and processing of personal data is compliant with the GDPR. For instance, in this case, Eventbrite is based in the US, so when you plan your event, you will also need to wonder whether you will need a legal basis for the transfer of personal data and on which one you are gonna rely. And then other two pieces of information for the individuals who will sign up to your events. The first one is, of course, providing them with the full privacy notice if they are very interested in the way you collect personal data about them. And, of course, the last sentence will also let individuals know how they can contact you if they have questions about their privacy. And we now keep talking about your daily activities and how to comply with the GDPR in the course of your daily work, and we will address the fundraising activities.
Thank you, Diletta. So indeed, let's now focus on one activity that is very critical for public interest type of organization, given the financial constraint there are in, and we'll briefly touch on processing activities as part of fundraising campaign. So not only it's something that is important to you, but it's also something that received a lot of attention from supervisory authorities. If you remember, even prior to GDPR, a couple of data protection authorities around Europe enforced or were against organizations that were using and collecting data as part of their processing activities. And in fact, fundraising cannot be just seen as one single activity. If you consider fundraising, you should probably consider the various aspects of it, and then attach a legal base for processing for each and every category. By launching or when launching a fundraising campaign, there are different things you do. So first, you probably analyze who will be your potential subscriber, and you eventually reach out to them to see if and when they are ready to support you. Then you also need to actually process the subscription or the donation you receive, and for that you need to process payment data. And then eventually you may be willing to share donors' information with other NGOs that even have the same type of goals or more broadly. Each of those different activities has a different or will rely probably on different type of legal basis, or at least you need to consider each of them to see the legal basis that is the most appropriate. If you take payment processing, probably you don't need consent for that, but you can more easily rely on the performance of a contract legal basis, because indeed, by the time someone agrees to donate or to make a donation to you and just need to effect that donation, it is a contract between he or she and your organization, and the type of data you will collect is just and only the one that is necessary for the payment to go through. For all of the other type of activities, it will be hard for you to justify that you don't rely on consent of data subject, because it's a relatively intrusive manner, let's say, to go and reach out to people to seek for their money. And that is typically something for all of those other type of processing activities you will be doing as part of fundraising. It's something that you will need or where you will need consent as a legal base. As we mentioned already, data subjects are empowered with a number of rights, and not only rights that they have under the GDPR, but also under other type of legislation. Especially when you reach out to people, they have some rights attached to the way you will be able to reach out to them. This example over here is one that we took from Oxfam, where you can really see that data subjects are receiving a choice on the best communication channel they agree or accept to be contacted. And Oxfam here gives people the choice between contact by email, by telephone, by post, or by even text message. And still, and for the same reason as we discussed before, all of that comes along with some indication on what type of data are collected, and a link to the privacy policy that's probably much more noticed than a policy, but enabling you or the data subject concerned at least to look at what kind of data are collected and the reason and rationale for that collection to take place. That's for the key component of fundraising, and we'll now move to the final activity, which is stakeholder mapping. Organizations may need to keep a list of stakeholders and their representatives, including, for example, name of policymakers and regulators, organizations representing similar or opposing interests, or a list of journalists who follow a given topic. That is often referred to as stakeholder mapping, and it received relatively high attention as well, especially in relation to EU lobbying agencies and the likes. You may argue that you collecting those type of data on all of those persons is something that you do based on your legitimate interest, and you will justify your legitimate interest as you requiring to collect information that you will be using for your advocacy purposes. And that sounds valid, but as you will remember from Diletta's explanation on all of the boundaries and the constraints using legitimate interest as a legal basis, there are things you'll need to consider when you do so. You will be able to explain and justify your choice, and in particular that you pass that balancing test that Diletta talked to you about, so that indeed that all of those data you are collecting from individuals and all of the rights that those individuals may seek and have are not overridden by your own interest in tracking all and collecting all of those data. You will need to inform data subjects in your privacy notices, and not only inform them, but also inform them on a timely manner. That might prove to be more complicated when you are indeed collecting data from, for example, public sources with limited outreach to those actual individual concerned, but it's something you will need to factor in your compliance. But probably more important for these purposes, you will need to consider the data minimization requirement that I spoke to you just at the very beginning of the presentation, because it's one thing to collect and process personal data as part of those activities. It's another thing to keep way too much data on those individuals. So if, for example, what you are mapping is the position of given individuals on a specific piece of EU project, for example, it has nothing really to do to collect non-connected data, such as, for example, if the individual concerned is married, or whether he has children, or what kind of center of interest or hobby those people can have. So really, the key message here is to know and realize that dealing with those kind of processing activity is a sensitive area that really requires you to have a particular attention as far as GDPR compliance is concerned. And this closes today's session. We hope you find it useful. Should you have any question on what we discussed, feel free to reach to both of us, and we'll be more than happy to answer questions.